Step out of the vehicle. This car comes back as possibly stolen. The registration is in my name, officer.
I said step out of the vehicle. On what basis? You're holding my license. Hands on the hood now. My name is Denise Coleman. I'm a United States magistrate judge, and that registration in your hand is mine.
At 7:38 a.m. on March 4th, a Tuesday, Officer Tyler Brennan put handcuffs on a sitting United States magistrate judge in a tailored Navy suit over a stolen vehicle report for a different make, a different model, and a different year. He thought the car was too nice for her. He thought she didn't belong in it. Within 48 hours, the footage from his own body camera would pass 2 million views. Within 14 months, it would cost the city of Westvale $7 million, end his career before his 25th birthday, and trigger a state review of a pattern his supervisors had filed away. Twice, his career was over. He just didn't know it yet. Before we continue, where are you watching from? If this is your first time here, hit subscribe. Stories like these need to be shared, and your support helps us bring more truth to light. A quick note before we go further. This account is based on documented patterns drawn from civil rights cases across the country and represents a composite of real, recurring experiences. The details are constructed to reflect how these incidents actually unfold. The Honorable Denise Coleman had spent 11 years on the federal bench. Appointed a United States magistrate judge in 2014, she handled the unglamorous machinery of the district, search warrant applications, pretrial detention hearings, the discovery disputes that decide cases long before a jury ever sees them. Lawyers who appeared before her described her the same way, prepared, unhurried, impossible to rattle. That morning she wore a tailored Navy suit and drove the charcoal Mercedes-Benz E-Class she'd owned for 6 years. Registered, insured, and parked every weekday in a reserved space at the Howard M. Castellano Federal Building, a granite and glass courthouse completed in 1968, where she was due to take the bench for an 8:30 motions docket. Officer Tyler Brennan was 24 years old, 14 months out of the academy. His personnel file, later marked Exhibit C, carried 2 prior citizen complaints, both for stops his supervisors had quietly stamped unfounded without a full review. Academy evaluators had flagged something specific about him, a tendency to assert authority well beyond his training, and a habit of treating compliance as the only acceptable answer. Those evaluations were read once and filed. The department was short 40 officers. Brennan had cleared minimum requirements. That single staffing decision, a box checked on a hiring form in a building neither of them would ever see, is the reason these two people met at 7:38 on a Tuesday morning. Linden Boulevard runs through Ashmore Heights, the wealthiest district in the county. Wide lots, old trees, almost no foot traffic before 8. Brennan had been assigned a solo patrol of the area for 3 weeks. According to his own activity log, he initiated 19 traffic stops in that window. 14 of the 19 drivers were black. At 7:36 a.m., he pulled in behind a charcoal Mercedes idling at a stop sign. He did not run the plate first. He would later claim the vehicle matched the general description of a car flagged in a stolen vehicle report from 2 counties over, a report describing a different model, a different color, and a different year. He activated his lights at 7:38. Judge Coleman signaled, pulled to the curb immediately, and came to a complete stop. She had 42 minutes before her docket. The body cam footage opens with Brennan approaching the driver's side, hand resting on his belt. The first 90 seconds are almost routine. He asks for license and registration. Judge Coleman hands them over. Registration in her name, address matching the car, everything in order. A competent stop ends here. The documents resolve the only stated reason for the stop. The possibly stolen theory collapses the second he reads the registration. Instead, Brennan held the documents, glanced at them, and ordered her out of the vehicle. She asked why, calmly twice. On the footage, her voice stays level, the same register she used on the bench when a young attorney was about to make a mistake. She told him, again, that she was a federal judge, that her courthouse was 9 minutes away, and that he was welcome to confirm the registration through dispatch. He ordered her out a 3rd time. What he said next is the line the city's attorneys would spend 16 months trying to keep out of a courtroom. Judge Coleman stepped out. She placed her hands on the hood without being told twice. She did not raise her voice, and as Brennan moved behind her and reached for his cuffs, the body cam captured him clearly. The body cam recorded Brennan saying, "Peep you like you don't drive cars like this." 8 words, no ambiguity, no missing audio. A trained officer narrating his own assumption into a department-issued microphone while placing handcuffs on a compliant woman whose registration he was holding in his other hand. She was cuffed at 7:44 a.m. and walked to the curb. Brennan called for a supervisor and finally ran the plate, the step that should have been his first, at 7:46. Dispatch came back inside 90 seconds. Registered owner, Denise Coleman, no flags, no stolen report, nothing. He did not uncuff her. Quick question for you and sit with it for a second. It's 7:46. Dispatch has just confirmed the car is hers. She is standing on a public sidewalk in handcuffs, and the officer has every fact he needs to end this. At this exact moment, is what you're watching a mistake or a decision? Tell me below. Because for the next 16 minutes, a sitting United States magistrate judge stood handcuffed on that sidewalk in a navy suit, while Brennan waited for his sergeant and wrote in his notebook. A deputy U.S. Marshal named Anthony Reyes, driving to the same courthouse, recognized her from the road. His witness statement, filed later that week, documented the time, the location, and the fact that Judge Coleman stood silent and restrained while the officer made no move to verify what dispatch had already confirmed. The sergeant arrived at 8:04. He took one look, ordered the cuffs off, and apologized. Judge Coleman was released at 8:06 a.m., no citation, no charge, no report of any crime because there had never been one. She had been detained for 22 minutes. She did not file a complaint at the scene. She did something Brennan was not prepared for. She went to work. Judge Coleman reached chambers at 8:21. She took the bench at 8:30 and heard her full docket. Then that afternoon, she did the one thing a federal judge is uniquely positioned to do. She filed a formal written request for the body cam footage, the activity logs, and the stop data for Brennan's entire patrol assignment, through official channels on the record in writing. A roadside complaint can vanish. A documented request from a federal judge, copied to the department's legal counsel, cannot. Within 48 hours, the footage leaked. No one has ever established who released it. What's certain is what the public saw. A compliant woman, a confirmed registration, and an officer saying 8 words into his own camera. The clip cleared 2 million views before the department issued its first statement. By the end of that week, Brennan was on paid administrative leave, and Internal Affairs had opened a formal investigation. The Internal Affairs investigation took 5 weeks. Investigators reviewed the body cam, the dispatch logs, the stop data, and Brennan's personnel file. The findings were sustained on 3 counts: an unlawful detention extended past the point dispatch cleared the vehicle, a Fourth Amendment seizure violation, and conduct unbecoming. Then the stop data did the real damage. Of Brennan's 19 stops in Ashmore Heights, 14 drivers were black, in a district where black residents make up under 9% of the population. Combined with the 2 prior complaints supervisors had waved through, it stopped looking like one bad morning and started looking like a pattern of part of the department had been warned about and chosen to file away. The chief moved to terminate. Brennan's union grieved it. At the disciplinary arbitration, the 8-word recording was played once. The arbitrator upheld the termination. Tyler Brennan was fired 4 months, and 1 day after the stop, his certification referred to the State Board for decertification review. But firing the officer didn't close the case. It opened the more expensive one, because the lawsuit that followed wasn't really about Tyler Brennan at all. Judge Coleman filed suit in federal court under 42 U.S.C. 1983. The complaint was precise. Count 1, Fourth Amendment, unreasonable seizure. The detention continued after the stated justification was confirmed false at 7:46 a.m. Count 2, 14th Amendment, equal protection. The stop data and the recorded statement established race as a motivating factor. Count Monell liability against the city, failure to train, failure to supervise, and a custom of stamping complaints unfounded without review. This is the count that turns a personnel problem into a municipal one, and the count that puts a city's budget, not just an officer's pension, on the line. The city settled 16 months after filing before the footage could be played for a jury. The agreement, $7 million. A 22-minute detention with no physical injury does not, on its own, command that figure. Most wrongful stop cases settle well below it. What drove this one was the Monell exposure, the documented pattern, the 2 ignored complaints, the recorded statement, and a plaintiff with the standing and the resources to take it the distance. Cities pay to keep that combination away from a jury. Roughly $2 million of the total was earmarked to fund the reforms the agreement required, and it required real ones: an independent audit of the department's traffic stop data, mandatory bias and Fourth Amendment retraining, and a new rule forcing every citizen complaint through a documented review instead of a quiet unfounded. Here is the part that should sit with you. Denise Coleman won because she could. She knew the statute by its number. She knew how to demand the footage in writing. She had a deputy U.S. Marshal as a witness and a courthouse full of colleagues. Almost no one stopped on Linden Boulevard has any of that. The 14 other black drivers Brennan pulled over in 3 weeks did not get a 5-week investigation. The 2 people who complained before her got an unfounded stamp and silence. The system didn't correct itself because an officer crossed a line. That line had been crossed for 3 weeks in plain view. It corrected itself, briefly, because the person in the handcuffs happened to be one of the few who could force it to. That's not accountability. That's luck wearing a robe. And a system that only answers to the people powerful enough to make it isn't protecting the rest of us at all. If you believe stories like this matter, if you believe accountability shouldn't depend on whether the person in the cuffs happens to know the statute by heart, hit subscribe. We're documenting the patterns the system would rather file under unfounded, one case at a time. This isn't about one judge or one officer. It's about every person who's been told they don't belong in a space they earned. We'll see you in the next one.